Welcome back to another episode of Divorce at Altitude. After quite a break, we are back, and this episode I am joined by my lovely co-host, Amy. Amy, what are we talking about?
We're talking about all those complex assets that no one seems to know how to divide. So we're trying to give a pathway to help people understand what they are, how to value them, and what to do with them in divorce.
Indeed. And you did a presentation on this at Family Law Institute in Vail. It's the annual Divorce Lawyers Conference or Family Law Lawyers Conference. I wasn't able to make it because I had some kid responsibilities or children responsibilities, but everyone came up to me afterwards and reached out and said, this was the best program of the whole conference. Let's start off and talk about why these assets matter, Amy.
Yeah, so as I think we get into having more technology, we have like cryptocurrency, we have these types of things that are coming up. And as divorce attorneys and people going through divorce, we have to figure out what to do with them. So when you look at businesses, we've talked a lot about like business valuations. A lot of times what's coming up in my cases, and I'm sure in yours, Ryan, are RSUs, and those are restricted stock options. So can you just, for our audience, remind them like where this will come up and kind of what we're talking about when I say RSU?
Yeah. So if we go back to our hypothetical divorce clients, Eric and Melanie Wolf, if Eric is working for some sort of company, and often it's either a private company or it can be a public company. So let's say that in the news right now is NVIDIA. So NVIDIA, Eric is a some sort of software engineer, and he is compensated through salary, but he'll also get issuance of stock. And the most common is in the tech world. It's really common in those industries, but Eric he'll be issued restricted stock. And so there may be various restrictions on whether he can sell, it could be locked up, and there's other aspects. And so Amy, talk to me a little bit about the valuation and why this might matter. And also what kind of common pitfalls or things that you see in terms of these being overlooked in divorces.
Yeah, so the kind of the starting framework is always when you're figuring out if something needs to be valued or even if the divorce court has the ability to deal with it, meaning jurisdiction, you have to look at the property statute. So we have to first figure out, is it property? Is it marital? Is it separate? And so what gets complicated with RSUs is understanding, is an RSU property or is it not? Is it marital? So you really need to look at the employment agreements on these things to figure out how they're valued and when they vest. Because a lot of times clients will give me a statement that says, here's the vested amount of the RSU and here's the value. That doesn't necessarily mean that's the only marital portion. So a lot of times we're pulling in experts to come in and look at the valuation because we have certain cases that we look at, such as like intermarriages of Miller, where options that require employment after the divorce are not marital property. We also have Balancin that we look at, which if some employment conditions are already met, a portion of the stock, even if it's not vested yet, might be considered marital. And we also have intermarriage of Powell that we're looking at the employment contract to figure out, is there an enforceable right? Is this property? And so we have to look at what are the conditions. So it gets pretty complicated pretty quick. And I'll look at these agreements, but a lot of times I will consult with an expert to help me with it as well.
Yeah, you mentioned stock options. I want listeners to understand, Eric, it's the same beast and they're fairly common, but they're distinctly different from restricted stock units or RSUs. So just so people can understand, stock options would be Eric Wolf works for NVIDIA. He's issued options. The option would allow him to purchase NVIDIA stock at a set price, and that price might be $100 a share. And the NVIDIA in a year when those options vest could be at $200 a share. And so he'll exercise the stock option. There's what's called a strike price. The strike price is $100. And then he can immediately have $100 of appreciation, and that is taxed at long-term capital gains if it's a year. And it can get really complicated because Eric Wolf will say, I'm not vested and I don't have the vesting. And so a lot when we talk about vesting, Amy, what are we talking about in terms of vesting?
So vesting means like at a certain date, essentially you can sell it at like that strike price. So a lot of times you'll look at these grant agreements and there might be, a lot of times they're over like a 3-year period is what I see, where certain shares will vest and you can, like the strike price, the value is that as to that date. So a lot of times you'll look at the grant agreement and there will be some that are not, you can exercise those, essentially those stock options at that date. So I don't know if that answers your question or if you have anything else to add.
I think that for people, they want to understand that it can get really complicated. But Eric, another kind of example I think that might be helpful for people to understand vesting is that Eric Wolf could be given certain shares or stock options. And to incentivize him to stay at NVIDIA, he won't be able to exercise, or they won't actually be vested for 3 years. And they could be in year 2 of that vesting schedule during the divorce. Okay. So then we've got this issue of he's exercised or he's done a year and he's earned time towards that vesting, but he can't actually do anything with the stock options. And so he will come to me, Eric, and I've had these clients and they say, there's no property because it's not vested. And the answer is really, it's not so fast and it's not so clear. If you have an enforceable right and it can be property, but then you've got that 3rd year that would be earned after the divorce. So you have these kind of sliding scales of separate and marital property. And Amy, when you're talking about the something off in the future, and then we also mentioned taxes, we mentioned kind of possibilities. The other aspect I want to mention is that the vesting might not always be based on time. That's a super common methodology, but there could be performance metrics if the company hits a particular revenue or they do this or that. It really depends. And so it gets really complicated, and that brings in experts. So maybe talk a little bit more about the use of experts, in particular with RSUs and stock options.
Yeah, and it can get really complicated, and why we have to bring in experts a lot of times is that if we're looking at a date of divorce and if some of those shares we determine that they're during the marriage, then we have to figure out what the value is. And sometimes it can be easier if it's like a publicly traded company versus like a startup. So I think a lot of times what the business valuation expert can come in and do, and they can look at the grant, but they can also look at the employment contract. And sometimes we actually will talk to key people within the company to figure out, are these considered earned or not? So it gets complicated in that analysis. And also looking at, if you are going to, when we're talking about dividing these, one of the options that I find is really helpful is to put this type of property into a constructive trust. And the language in the separation agreement needs to cover, well, when they're exercised, like how are you going to figure out what they're valued at? How are they going to be paid out? How do you deal with taxes? What happens if the company is sold? So it's all of those options that I'm working with the business evaluator, not only to value, but also to help me with coming up with some of those pitfalls, the language to put in the agreement to make sure that I'm covering every scenario that could happen if I'm putting that in a constructive trust.
Yeah, and going back to, if people want to learn more about the options and experts, there's episode 111. It was what to do with stock options and a divorce with Ken Nays. But going back to what you were saying, Amy, is that you can either value, I want people to understand there's kind of 2 major paths that you can go down. One is you value it. So Eric Wolf, we would say these options, the marital portion is worth X. And then the separate property component might be worth Y. And if the marital portion is, let's say, worth $500,000, then, does Eric, if you're doing an equal division of property, he's got to come up with $250,000 in cash or some other property to offset that with Melanie Wolf. And then the other option that you were mentioning, Amy, is the in-kind division, or putting it in a constructive trust and saying, we don't know exactly how much these are worth right now, or we don't want to argue over them. But it could be in a year or 2 years. And then it could be that we're going to equally divide whatever that amount is, or 60-40 or whatever it is. And oftentimes we'll say we'll divide the net amount because you got to account for taxes. And so it really depends. The pro on the valuation component in terms of in the divorce is that you have a value, you have certainty, but then Eric's got to come up with cash or some other property, and there might be liquidity issues. And I think, Amy, it's safe to say that these issues can be overlooked oftentimes, and people may not even know. Eric Wolf can come in, like I referenced earlier, and say, there's no property. It's not vested. There's nothing to see here.
Exactly. So I think if I'm Melanie's attorney, I need to make sure that I'm getting all of the documents I need from Eric's company, and I'm going to be consulting with my expert. Sometimes we put them in a constructive trust because there might not be enough money to pay out Melanie for her 50% portion. But in the higher asset cases, maybe there is. Yeah.
Okay, switching gears a little bit, it's related to the constructive trust, but talk to our listeners, Amy, about the time rule and some of the expert models that exist out there in terms of calculating the marital versus separate portion in these complex assets.
Yeah, so we use a lot of times it's called the time formula, and that means because some of the options are earned like during the marriage, some of them might have been earned prior to the marriage, and so we have to figure out some kind of I'll call it like pro rata split to figure out what is the marital portion. So essentially, to figure out the marital portion under the time formula, you take the time employed during the marriage and you divide it by the total time from the grant to the vesting. So that's just in general what the time formula is. And we look at the fair market value of the option at the vesting date. And a lot of experts can also use the Black-Scholes model that a lot. And it gets a little more complicated because you have to look at, there's also discounts that are put in place. And so depending on the company, the discount can vary. So that's what we're talking about when we're talking about time formula plus the valuation techniques that experts will use.
The issue that I frequently run into, Amy, is so you both have a property interest, which we've been really focused on, but then you also have this income component because you can be taxed or gifted depending on the circumstances of the stock options or the RSUs. If historically Eric Wolf has received these RSUs or stock options and then sold them and then used the proceeds to pay for the lifestyle, there can be some complications there. But I will identify the issue, and then oftentimes I'll bring in a shadow or rebuttal expert or someone to help me figure these issues out. And can you talk to me a little bit about what different kinds of experts and their roles we've talked about on different episodes, but in terms of complex assets, what are the role of shadow and rebuttal experts?
Yeah, so I will bring, and I'm sure you will do the same thing. Sometimes I bring in my shadow expert. If I'm not so here's the options that you have. So under the rules, essentially it says you have to try to confer to have joint experts. A lot of times with these higher like asset cases, attorneys will have their own experts. If you have a joint expert, that means it's hired by Melanie and Eric to essentially value, let's call the RSUs. You can bring in, if I'm Melanie's attorney, I can bring in my own expert that's called like a shadow expert that I don't have to disclose right away. And I am as the attorney and the client. And the reason why I'm doing that is to protect work product. But essentially the shadow expert can help me as Melanie's attorney pose certain questions to the joint experts, get certain information. And then you can also use a shadow expert on the other side to do a report in response to the joint experts report if I don't agree with it. So I don't know if you have anything else to add to that, Ryan.
No, I think that it really depends on the circumstances. And one issue that we always deal with is the costs in terms of what are we talking about? Are we talking about like just 100 stock options that are worth at most $10,000? Or are we talking about a slew of restricted stock? I think that is a conversation that any attorney needs to have with their client, both on Eric or Melanie's side, in terms of what are the kind of issues and is the juice worth the squeeze? And so those are the sorts of issues that I think people underestimate in terms of the costs or possibly overlook. And one thing that I think often is that you have these kind of binary viewpoints by Eric or Melanie is it's all marital or there's no marital portion at all. And I think that it's usually a combination, or not a combination, but it's far more nuanced when you consider the often separate property components, because you often will have vesting or these options, and there's future work that is done. And that brings up intermarriage of Sewell and some other cases. Sewell is, I'm a Broncos fan, and I grew up rooting for kind of the John Elway and old Broncos, dates me, but Steve Sewell was a well-known tight end. And one of the issues in his divorce, he went through a divorce, was a Pro Bowl bonus. And he got divorced in the middle of the season. And it was whether or not he had a contractual right to a bonus. But it was for the Pro Bowl, and the Pro Bowl, for listeners, that it was played after the season. And so the legal issue was that bonus, marital versus separate, which is similar to Eric Wolf working at NVIDIA, and he's got this future vesting of stock options, is that he's got the right to it now. And so there are kind of analogies and different issues, and Eric, when he comes to us, is usually quite shocked to learn that it can be property.
Yeah, exactly. And I think the last thing I'll leave with is just more of a creative way where it doesn't have to cost. You don't have to have 3 experts and the cost of a shadow. I guess it's shadow rebuttal. Sometimes if you're going to mediation, you can hire the expert, such as like a Ken Nays, to come in and just do the valuation schedule. Or I can consult with him to say, can you help me with these discounts? What is appropriate and why? So you can really utilize these experts in a way that is more cost effective. So that's helpful.
And I think that people need to we talked about some actionable items and some kind of common pitfalls. So one thing I think is identifying the issue from like a lawyer's perspective is we identify the issue, talk to the client, and then really do we involve experts? And if so, we should probably do that soon. And then you get into the joint versus retained versus rebuttal versus shadow. And then, but if you're going to deal with it at a high level, if you're going to deal with it and say, listen, we're going to have an in-kind division, okay, that's fine. But a lot of times people wait a little bit too long, and then they decide, okay, this is actually complex. And then it just drags on, and then people start getting frustrated. I once had a case where the vesting was coming up like in 3 months. And then my client quit right before the vesting because he said, I'm not going to have this windfall. And then there was a dissipation claim. It became really complicated. And so I think 95% of divorces out there don't involve these complex issues, but when they do, it can be a meaningful material issue that is involved in someone's divorce.
Yeah, and I think as attorneys, we know our lane, we know what we're experts in and not. And so when you're looking at RSUs, consulting with an expert a lot of times is necessary. Yeah.
And then the final thing I think just to throw out there is that there is other forms of deferred compensation. Doctors, for example, I've seen, or financial professionals, people that work on Wall Street, they'll often have these significant deferred compensation plans. And the reason that they do that is for taxes. There can also be backroom handshake deals because of a looming divorce. And so there are different kind of components to all of this. And when it gets complex, that is something that people need to be aware of because it can really matter for people. But I hope people have learned something from this episode. There's no bright line rules, but thank you for joining us on Divorce Altitude.